The ACLU gangbangers would say this, of course, is completely unlawful, but I think more broadly than this point, they're trying to invalidate the entire proclamation. The Fourth Amendment is meant to protect that. Now, on the same side, you see a lot of what's happening here is the illegals come in and then exploit the laws, right? They come in, no, I deserve the same rights as every single other U.S. citizen. I deserve a trial by a jury of my peers to make a determination that I'm an illegal alien or something like that. A newly released memo from Pam Bondi in the DOJ is raising some eyebrows out there saying, is she authorizing warrantless searches of your home, right? We always talk about illegal aliens and illegal immigrants, but what if the feds break into your house and they think that you've got an illegal alien inside and you're a citizen and you say, hey man, I've got Fourth Amendment rights to be free from illegal, unlawful searches and seizures in my home. Does this memo give the DOJ and the government the power to do that? Because if it does, that's going to be a big problem for everybody, not just the ACLU gangbang lawyers, but everybody in America. And so this memo was now released. You can see it was officially published some time ago, March 14th, coming out of the Office of the Attorney General, Pam Bondi. And this is guidance for implementing the Alien Enemies Act, right? And this is kind of a new thing that has been a part of the enforcement under the new administration, the Alien Enemies Act. It wasn't originally invoked for Tren de Aragua or MS-13, but now it is. And so she's issuing a memo on this, saying, the president's proclamation titled The Invocation of the Alien Enemies Act is now in effect, and this guidance shall take effect when the proclamation is made public by the president. Okay, so once it's in effect, this is how we'll do it. So here's what they tell us. For the purpose of this guidance memorandum, an alien enemy under the proclamation is one of these people. Okay, Venezuela, 14 years of age or older, not a lawful resident, and member of a hostile group like Tren de Aragua in particular, and was determined to be that as referenced by another form. Okay, and so just to be clear, like this is due process, by the way. We're processing people, fill out the form, make sure the form, there's going to be checkboxes in the form, it's valid, this is this person. Yes, we checked this record. Yes, we did this thing. Here's this. So we fill it out. It's for Tren de Aragua, for alien enemies. But again, right now, what if you're a citizen and you're like, well, I'm not Tren de Aragua, and they think you are, or they think somebody's in your house, or let's say somebody swats you or something, right? Hey, Rob Gouveia's got 3 Tren de Aragua gangbangers live in his casita, right? Outside. I don't have a casita, but if I did, somebody could say that. And maybe we get raided. Well, I don't want the feds coming in here without a warrant or without probable cause or exigent circumstances, which we'll come back to get into the house. So they say, all right, so now we know who we're talking about, Tren de Aragua. And so it's questions about validating that essentially and what they can do around that issue. All aliens who are determined to be alien enemies under the proclamation shall be issued a notice and a warrant of apprehension and removal under the Alien Enemies Act, except as provided in Section 8, right? So they're saying, okay, so we got warrant here, so okay, and notice. And by the way, that's due process. Okay, notice, a warrant from some other entity, in this case, an immigration judge. It's an independent check on the people who are doing the work. So if somebody signs a warrant of apprehension, there's notice and more, and removal. You get notice about your removal. So it's all there. There's due process in here, even by Bondi's own memo. Now, in effectuating the removal of aliens, law enforcement officers and agents must follow the procedures below. So let's go through them. Step 1. Validate their status. Actually go through the form. AEA 21A says at step 1 of the proactive apprehension of these people, a line officer or any other available officer is responsible for determining whether an individual qualifies as an alien enemy. Like, how do you check these boxes? Now, as outlined above, that requires determining that an individual is at least 14, not a citizen of Venezuela, a member of Tren de Aragua. Okay, so there's like 4 check boxes. Fill out the form, checked it, checked it, checked it, checked it, got it. The form guides the analysis of each of these 4 requirements. So it's step 1, you got to fill that out. It says go here, check this. It's like TurboTax. Okay, click, okay, got it. As outlined in the form, there may be instances where removal proceedings under the INA, the other law, like the status quo law, would be more appropriate. Okay, so we don't even need to use the AEA. Send them back to the INA and just process them normally. Line officers should adhere to the instructions, consult their supervisors and more before you decide. Should we go the AEA route or should we go the INA route? Now, at the conclusion of step 1, if all 4 of those checkboxes are satisfied, the line officer must then validate the subject, so someone else checks it, as an alien enemy by validating it. So one person does the work, another validates it. So 2 people are looking at it. Thereafter, a supervisor must review the line officer's determination and approve the reviewing officer's determination by signing in the space allotted there. 3 people? You got the line, you got the reviewing, and you got the approving. So 3 people are checking this. Golly. In this supervisory review, the supervisor may consider all relevant facts, including not limited to, supporting documentation and more, including alienage, connection to trend. The supervisor may request additional info if you want. Once you got these 3 people, then the supervisor approves the line officer's validation, and then the supervisor must issue a warrant of apprehension and removal for the subject alien enemy by the subject line titled Notice and Warrant of Apprehension. So again, they're calling it a supervisor who signs the warrant of apprehension. And again, this is all under Article 2, the executive branch under immigration. And so it would be, even, for example, Kilmar, when he was going through the proceedings, he was seeing Article 2 judges, immigration judges. The judge who issued his so-called withholding of removal was an Article 2 judge called David Jones, who works for the Department of Justice, which is Article 2. So in other words, they're still keeping it in Article 2. She's not calling it an immigration judge. She's calling it like a third line supervisor. Now, to the extent possible, before apprehending an alien enemy, you should conduct standard conflict checks to ensure it's consistent with the interest of justice. And then we get into apprehension. Okay, so this is all validation, so we're not even really talking about the warrant stuff quite yet specifically. But after a supervisor issues a warrant of apprehension, and you can see where this might be a problem, right? Like if the executive branch is issuing warrants for themselves and then executing warrants based on their own warrant, you can see how that could be a problem without an independent judiciary weighing in on the validity of that warrant. So let's continue. And deconfliction is complete. Officers shall use all available tools to immediately apprehend validated alien enemies wherever they're found, including but not limited to inside alien enemies' residences and workplaces. If you want to mirror this, it's essentially like what cops are doing in general, right? They're investigating crimes, they're creating their case, they're validating that there's cause, and then they conduct an arrest, right? Okay, we got this guy. We've been scouting this out. Okay, fine, validate it and go conduct an arrest. Now, in some cases, they'll get warrants for those, but in some cases, they won't, right? If they're just watching somebody and a crime is being committed and they say, oh, we've got enough cause to go in there and arrest that person, they go do that without a warrant because they've seen that cause and come to that conclusion as sworn members of law enforcement, right? So then they conduct the arrest and it proceeds according to standard cause, probable cause. Now, prior to entering an alien enemy's residence to apprehend an alien enemy, officers must have reason to believe that the validated alien enemy is present inside the residence, right? So now you get into this problem. What if this alien is living with you, who is a citizen, and you don't want them coming into your place without a warrant, but they got a warrant that's, basically granted internally for them. So now we've got this conflict with your citizen rights. So to be clear, she says, as outlined below in the section titled Apprehension and Removal, it is not necessary to complete these forms prior to apprehending an alien enemy where an officer has a reasonable belief that all 4 requirements to be validated as an alien enemy are met. Okay, so it's like you fill this out as a standard practice where it's like, yeah, as many even officers will tell you, it's better to go get a warrant, but you don't always need a warrant. Just kind of depends on the circumstances around you. So if you're, for example, interfacing with somebody and you go, oh yeah, this dude checks all 4 of those boxes clearly, you don't have to fill out the form immediately. You can just conduct that arrest. Now, in those circumstances, officers are authorized to apprehend the alien enemy and then complete the forms after the fact just to validate it, right? And so you'll see this a lot. Like, for example, they'll pull you over, they'll say, oh, you're definitely drunk, you're driving under the influence. They'll conduct the arrest, then they go out and they fill out the forms. They fill out the field sobriety sheet, they fill out the police report, all those things, and they say, we've now got probable cause to believe that we should conduct this arrest. You're arrested and charged with a crime. So kind of the same thing, right? Same thing happening there. Now, while a judicial or administrative arrest warrant is not necessary to apprehend a validated alien enemy, to perfect apprehension operation plans, officers should consider consulting federal prosecutors in relevant districts to obtain criminal search warrants, right? Because if you're going to prosecute them with a crime, so now we're talking about 2 different justifications for the search. One is to charge them with a crime. The other is to remove them. So if you're going to be charging them with crimes, go talk to the criminal prosecutor and get their opinion on this so that they can weigh in and validate what you're doing, because you're going to hand the case off to them ultimately, right? You're not going to remove these people since they're trafficking children or whatever. You're going to prosecute them and imprison them. So get their opinion on this for more. So here, there's other violations, for example. Like they might charge them with these crimes: failure to carry immigration documents, failure to register, smuggling and harboring, illegal entry, possession of firearm by alien, and more. Beyond these common crimes, because Tren de Aragua has been designated a foreign terrorist organization and specially designated a designated global terrorist organization, crimes including these other crimes may also be relevant to address this as well. So we need to bring the criminal component in, not just the immigration removal component. Now, while the ultimate goal is the immediate identification and removal of alien enemies, coordination with federal prosecutors who are required to support these operations at every step may enhance the officer's ability to conduct apprehension safely and efficiently, and may assist in the collection of evidence, identifying additional Tren de Aragua members in the vicinity of the single person who are to be apprehended. So it's like you go for one person, you fill out the forms for the one person, but you find, oh, this guy's smuggling like all these other gangbangers in here. So you just arrest all of them there and you validate them after the fact, right? It's just like we got plenty of probable cause to conduct the seizure of the person, and then we'll fill out the forms after the fact, essentially, because we have the same cause that we would have had in the completion of the forms. Now, service and notice, which again is pretty standard, right? So cops will see something, they'll conduct an arrest, and then they'll fill out the report and they'll explain their probable cause after the fact, right? This is why I arrested him, because I saw right then he was attacking this person. They fill it out. I didn't need, to go get approval to do that, because it was happening in real time. Upon apprehension, an officer must serve an alien enemy with the form and the notice and warrant of apprehension and removal, and must include a statement by the officer that notifies the alien enemy that, okay, this is all due process and notice now, saying the officer has been authorized to apprehend, restrain, and remove this person. He's been determined to be an alien enemy, determined 14 years of age or older, determined not lawfully here, citizen of Ven, member of Tren, not entitled to a hearing on any of this, shall be detained pending removal. After being removed, he may not re-enter the country. So what they'll scream about on this is that they're not getting notice. You're not entitled to a hearing or judicial review of this. So you're not entitled to, right? And this is where you get into the nuance, but they would say they are entitled to one if they request it. Okay. So now it's like the ACLU would want this to be changed to say you may request a hearing, but like we're not going to grant you an automatic hearing. If they request one under habeas, then they would be entitled to a hearing, but not, right? They're being very specific on this too. Like this is very careful legal crafting, which is wild to watch. Says you're not entitled to a hearing, appeal, or judicial review of this warrant. Okay, you can't challenge this warrant. But there's a subset here, which is, well, you could challenge it under habeas petition, petition for a writ of habeas corpus in the district where you're being detained. And like the ACLU and the judges, I think, would want that in there. Now, after serving the form upon the validated alien enemy, then the service officer must obtain the signature of the enemy and execute the certificate of service. If the enemy refuses, you just type refuse, write refused on there and just indicate that on the signature line, just like they do if you reject a ticket on the side of the road. So all apprehended aliens must be detained until removal is effectuated. That detention can occur any place that is suitable. Immediately upon apprehension, officers should commence arrangements and promptly remove this person, get them out. Now, what happens in reactive matters, right? This is where we talk about things that happen in real time right in front of you. Like the cops do their best to prepare for this stuff, right? And then other crimes happen in real time. You see other things, people flee, you discover new crimes, people try to destroy evidence. There's a whole body of law on this that's called exigent circumstances, and there's a long lineage of case law on this. In criminal law, okay, we talk about this in criminal law. In immigration law, this is kind of like an analog. You'll see them walk us through. But exigent circumstances, okay, these are defined a whole litany of Supreme Court precedent that says you actually don't need a warrant because there's an exception to the Fourth Amendment. And myself and a lot of Constitution-loving people think that a lot of these exceptions are way overbroad, that cops and judges, many conservative judges like Scalia and others, have just written huge gaping exceptions and holes into the Fourth Amendment that just give cops a lot of justifications that they use after the fact to conduct warrantless searches when they've got no right to do it. So here's how the Supreme Court defined it in Missouri versus McNeely. Says, a variety of circumstances may give rise to an exigency, an emergency, sufficient to justify a warrantless search, including law enforcement's need to provide emergency assistance to an occupant of a home. Oh, there's an emergency in there. I'm coming in. To engage in a hot pursuit of a fleeing suspect. Somebody's running away, right? You can go in there. You can enter a burning building, right? All those things. Of course, that has been expanded. Like these were exigent circumstances that have then been expanded, and it includes a bunch of other things like destruction of evidence, safety, plans to escape. Even some courts would say it's just impractical to secure a warrant, right? Now, we can't do it. So like the cops have a bunch of reasons, FBI, law enforcement, lots of reasons why the Fourth Amendment, it's more like a suggestion and cops needed a runaround to get around it and so on. And so this exists in the law. So if you see something that mirrors this in Pam Bondi's memo, it's already in existence in United States law, even though many of us have some concerns with how it is being used and implemented in practical purposes. But that's for American citizens, okay? So they do this crap for you if you're an American citizen. You walk in, oh no, we heard the toilet flush, so we thought you were destroying evidence, so we kicked the door in and raided everything. Oh, okay. Well, I was using the bathroom. Well, we thought you were flushing drugs, so valid. Oh, okay, great. So thanks for violating my constitutional rights. Prosecutor, do you care? No, not really. Judge, do you care? No, not really. Okay, cool. So not a big deal, right? So that happens all the time. You're a U.S. citizen, nobody cares. But if you're an illegal gangbanger, illegal alien, all of a sudden you get free lawyers appointed by Judge Rodriguez in Texas so that the ACLU can represent the entire class of gangbangers. So that, of course, is something that exists. And obviously we've got some concerns about it, but they tell us, as much as practicable, officers should follow proactive procedures above, right? Get the warrants, validate this before conducting an alien enemy. However, that's not always going to be realistic or effective in swiftly identifying and removing them. For example, consistent with the law, which I would mean to read exigent circumstances in criminal law and other protections and other exceptions under the Fourth Amendment, officers may need to contact the suspected alien enemy to develop further facts or otherwise confirm the four requirements. Or an officer may encounter a suspected alien in the natural course of enforcement activity, such as when apprehending other validated members of Tren de Aragua, right? Capture a whole group of them. Given the dynamic nature of enforcement operations, officers in the field are authorized to apprehend aliens upon a reasonable belief that the alien meets all four requirements and is validated, and it includes entering an alien enemy's residence to make an apprehension where circumstances render it impracticable to first obtain a signed notice and warrant of apprehension and removal. Now, whenever an officer makes a reactive apprehension, officers must thereafter complete each relevant step of the proactive removals outlined above, and prior to removal, must complete all forms described above, namely forms listed here. So I think this is where people start to get a little squeamish on this, because wait a minute, it's like there's no validation that there's not a citizen in that residence. So are we now have an illegal alien exigent circumstance kind of a interpretation? Now, you might also say, well, what if the alien enemy is living there alone? Are they validating that there are no U.S. citizens that might have a right to have their home free of illegal entry without a warrant, right? Because now we're not, okay, the illegal's in there, but now we're caring about the American citizen who's in there. And so, well, you might need a warrant, not need a warrant for him, but you need one for me, and I'm in here. So did you check to make sure that there's no other U.S. citizen in there or U.S. citizen interests in there? And I think that is concerning, because we don't want more exigencies, more exceptions to the warrant requirement being built into the system, because then they'll just, well, you got an illegal alien in there. We don't know. We can just come into your house for basically any reason, which they already can. They just find an exigency to do that. And here is this expanding that, right? I think it's a concern. Now, what I would also say is that this is here, right? Consistent with the law. In other words, you can't go beyond the Fourth Amendment protection. So if there is and this is a risk to them, I would say, if you're a citizen and you have cops come bang your door in and you do have someone who's undocumented in there, then you would say, wait a minute, I have a right to be free from illegal searches and seizures in my home. You should go get a warrant before you kick my door in. And your search and your kicking my door in was an unlawful entry in violation of the Fourth Amendment. And now your discovery of this illegal alien in my house is fruit of the poisonous tree. And you should not be able to use that evidence because you illegally entered the residence, okay? So like when you see consistent with the law, that's what a prosecutor would be thinking. That's what a defense attorney would be thinking. But if they just enter your residence and don't charge anybody with crimes, they just come in and just take that dude out, your rights still may be violated, but you may not have much recourse other than a civil claim against the government for damages, essentially. And you can see how that gets squirrely. So a lot of this is going to come down to implementation. You could make the argument that Pam Bondi is encouraging or actually mandating, right, to not violate the Fourth Amendment, follow the law. But as we know, there are tons of exigent circumstances, and this kind of reads like an exigent circumstance to enter a home if there is an alien enemy. But again, it's the alien enemy's residence. So it's like it's their house. It's not someone else's house. But you can see where it's getting close to that line there. Now, the ACLU gangbangers bangers would say this, of course, is completely unlawful, while simultaneously, I don't know what they would say about the rest of the Fourth Amendment jurisprudence, to be honest with you. But here, they would be screeching about this point, but I think more broadly than this point, they're trying to invalidate the entire proclamation. So it's interesting, saying there's also independent authority here. Okay, if you can just arrest them for other reasons, do it. Here's the record keeping requirements, no entitlements to hearings, saying, by the way, they're not entitled to appeal to immigration or judicial review, but they could file something for a petition for a writ of habeas corpus. She doesn't mention that, but they can. Ineligibility for relief, saying an alien determined shall be ineligible for any relief or protection from removal, again, within the DOJ, because the DOJ runs immigration. Reporting and apprehension, report everything to Christy Nome. These are other exemptions from removal. If there are some reasons why we may not remove people, if there's determinations made by other people, we might want to prosecute people, so we'll refer them over that way. Oh, and here's some forms. So here you go. As we thought, check boxes. Boom, checkbox. The person named above, not a citizen, citizen of Venezuela. Go through the forms. Here are the instructions, like TurboTax. Like all the Fourth Amendment search and seizure stuff, a lot of it comes down to implementation, and even many of these cases are analyzed as they go through the courts. When you challenge the search, right? When you challenge the seizure, when you challenge the evidence that was seized as a result of an unlawful search, the question is, what is the remedy? And a lot of those are dealt with on a case-by-case basis. This is what literally happened. This is the people inside. These are the people outside. These are the crimes charged. These are the allegations. These are the facts. These are the evidence. And then you just decide whether it was lawful or not. And so we'll see how Pam Bondi implements it. But you can see where there is maybe some overlap, where you can come up with a factual hypothetical and you say, wait a minute, a U.S. citizen, even if they're in alignment, maybe you charge them with a crime or something, right? But even a U.S. citizen has rights in their home, in their private residence. And the Fourth Amendment is meant to protect that. Now, on the same side, you see a lot of what's happening here is the illegals come in and then exploit the laws, right? They come in, no, I deserve the same rights as every single other U.S. citizen. I deserve a trial by a jury of my peers to make a determination that I'm an illegal alien or something like that. It's like, we know you're an illegal. You're not getting a jury trial to make that determination. So the empathy exploit, the legal exploits abound. And what we're watching right now is the Trump administration trying to come out like a Swiss Army knife to navigate everything, to do what's right for our country, to bring justice into balance, to get the illegal aliens in our country out of our country, and to bring America back.